Hello again, everyone. This is Attorney Grant A. Toeppen. I am an estate planning and probate attorney based in Manteca, California. I also have an office in Livermore, California. I do a lot of limited conservatorships. And today I'm showing you how I fill out the order appointing a probate conservator of the person for a limited conservatorship. Now, before we go any further, I'm going to give the usual caveat that nothing in this video constitutes legal advice. It's just how I fill out the form, and nothing in this video is to be construed as creating an attorney-client relationship between me and any other person or any other entity. So I did this one a little different than my other videos. I filled this one out beforehand. I thought I'd play around a little and see if this is more instructive. We'll see. So I'll explain as I go along and show each field and how I filled it out. So I'm pretending I'm not an attorney, so I have not put my state bar number here. I have put my name. I have put the best address to reach me. I have put my city, state, and zip code and telephone number. And in case anyone's wondering, this is all my office information. I'd never put my personal information out there on the internet like that. I am attorney for in pro per, Latin for self-represented. Superior Court, I am applying in San Joaquin just because that's where I do a lot of these. Typically, this is wherever the limited conservatee is domiciled is the correct court. I make sure I get the address right. Some counties have more than one courthouse, and I want to make sure I get the right one. If the mailing address is the same as the street address, I leave it blank. Conservatorship of. I've made up a name, put it here, John Smith. I typically file this at the same time I file my petition, so I don't have all the answers yet. So I leave a lot of it blank for the court to fill out. However, local practices, I imagine, vary widely on this, so I keep a very close eye on the probate notes, especially when I am applying in other counties. You can find the probate notes online. And I keep a close eye on the probate notes about 2.5 weeks before the hearing. 2 weeks, I start checking every day to see if anything has come up that requires my attention. And then I fix it as quick as possible and make sure the court is in receipt of whatever documents I have used to remedy the situation. So, the petition for appointment of successor conservator or normal conservator came on for hearing as follows. So of course you check this box if it was a successor petition. Judicial officer. I don't always know which judge is going to hear my case. Typically it is the wonderful judge Elizabeth Humphreys, but sometimes Sabrina Weiss-Coe, the judge pro tem, appears. So I would assume things like that could happen in any county where you would not know exactly who your judge is until it's signed, sealed, and delivered. Judges are people just like you and me. Sometimes they get sick and can't appear, and a judge pro tem, which is a substitute judge, like a substitute teacher, will come in and make sure everything gets done. So judicial officer would be put here. Hearing date and time, I don't know that when I'm filing the petition, and even then it might be continued from the original date. I leave these blank. Petitioner, Grant A. Toeppen. I am the one asking the court for the conservatorship in this example. I would, if there was an attorney for the petitioner, that would be here. If there is an attorney for the person cited, that would be here. I typically don't know who that is at the onset. San Joaquin, it usually is the public defender's office with John Lauper, but you never know. So I leave it blank. So F, the person cited was, and then you would say if, once again, I said you don't know the future, but I typically have a good idea when I file this if the conservatee, that's the person cited, the proposed conservatee was present, or if they are going to be unable to attend, or if they're going to be able but unwilling to attend, or if they're going to be out of state. And the conservatee on petition to appoint successor conservator was either present or not present. That might not be relevant, usually isn't unless there's a successor conservator petition, of course. So court finds. Here are the court's findings of fact. 2, all notices required by law have been given. 3, granting the conservatorship is the least restrictive alternative needed for protection of conservatee. 4, name of proposed conservatee, John Smith. is unable to properly provide for his or her personal needs for physical health, food, clothing, or shelter. This box I typically leave blank because that is only for a conservatorship of the estate, not applicable in the examples I am providing. Here, if the limited conservatee, the proposed limited conservatee, has voluntarily requested appointment of a conservator and good cause has been shown for the appointment, I'd click that. The conservatee is either an adult or will be an adult on the effective date of this order, or as a married minor, or as a minor whose marriage has been dissolved. 6, there is no form of medical treatment for which the conservatee has capacity to give informed consent. That is usually what is most important for the people I work with, so I always make sure that is checked because I'm always wanting to get those medical powers. Those are very important. So I usually don't check 2590. That usually comes up when we are dealing with a limited conservatorship of the estate, where there are assets that will need to be managed, and they might be difficult assets to manage. That tends to be the type under Probate Code Section 2590, like real property that's being leased, a business to run, securities to exchange. Unlikely to encounter that fact pattern with most limited conservatees, but I have seen it pop up before. I usually leave this blank. The conservatee cannot communicate with or without reasonable accommodations a desire to participate in the voting process. Does the conservatee have dementia? That's typically not an issue for disabled, developmentally disabled individuals. They're usually much too young. If an attorney has been appointed, I don't know who the attorney would be. I leave it blank. If I imagine the conservatee is not going to need to attend the hearing, I would check this box. But once again, you typically know ahead of time, and it's easier for the judge to check this box than to white it out. The appointed court investigator is, I typically leave it blank. They have a whole squad of investigators in San Joaquin County. I don't know who it's going to be. I let the court tell me who it is. For limited conservatorship only, always checking this for a limited conservatorship. The limited conservatee is developmentally disabled, as defined in Probate Code Section 1420. All right, so I would make sure to check that. So if the conservator is a professional fiduciary, I would check this. If the conservator holds a valid, unexpired, unsuspended license as a professional fiduciary, I would check this. For 16, either A, B, or C must be checked. Either I am not, either I am the conservator of the spouse of the conservatee, or I am the conservator, I'm the spouse of the conservatee, and I'm not a party to an action or proceeding against the conservatee for legal separation, dissolution, annulment, or adjudication of nullity of their marriage. So I'm not going through a divorce with the limited conservatee, the proposed limited conservatee. Or the conservator is the spouse of the conservatee and is party to an action or proceeding against the conservatee for legal separation, dissolution, annulment, or adjudication of nullity of their marriage. So not have to worry about that. I'm checking I'm not the spouse, but if I was, it would be either B or C here. So basically the same for 17, except replace spouse with domestic partner. I'm not the domestic partner. If I was, I would either check B or C and fill it out completely. The court orders here grant a Toeppen. If I was applying with someone else, I'd have that person's name too. If all the information didn't squeeze in here, I'd add an attachment. I'd fill this out and say see attachment 18 and 18A, and then I'd fill this out. But it all fits here. Here's my office address again. Is appointed limited conservator of the person of John Smith. Letters of conservatorship shall issue upon qualification. 18B, this part is only if I were applying for a limited conservatorship of the estate. 19, I let the judge check this one because the judge will make the determination if the conservatee need not attend the hearing. 20, for a limited conservatorship of the person, bond is just not going to be required. If I was asking for one of the estate, I would end up doing the work down here too and filling that out, but I'm not for this example. 20D, once again, this is going to be something that is more for a limited conservatorship of the estate. 21, I leave this blank. I let the court determine how payment's going to happen, if there's any payment at all, for the court-appointed attorney for the conservatee. If the conservatee has substantial assets and the court has appointed a private individual, as they do in some counties, Sacramento comes to mind, then this would be filled out. However, when it's the PD, the public defender, no, there's not a charge typically. And if if there's a fee waiver, typically the court will cover these costs as well. I leave it blank. I let the court decide on 22 if the conservatee is disqualified from voting. I do check this because I always double down. I like to make sure that it's clear to the court that we're asking for the medical powers, because that's so important and why most of these get started. So this little subsection, this is important for a lot of people. I haven't personally encountered it, but I just wanted to point it out. The treatment shall be performed by an accredited practitioner of a religion, as defined in Probate Code Section 2355B. This is for families or people who believe in healing by prayer or something similar, analogous. This would be filled out. That'd be checked. 24, once again, this is for more complex transactions of the estate. Nothing we have to worry about for a limited conservatorship of the person. So as far as orders relating to capacity of conservatee under sections 1873 or 1901 are granted, nothing I am going to need to worry about for this one. So orders relating to the powers and duties of the conservator of the person under probate code sections 2351 to 2358 are granted. I don't need to worry about that. I don't need to worry about 2402. I mean, all of these are basically for general conservatorships where you have someone who has suffered some major neurocognitive impairment later in life, not a limited conservatee who is developmentally disabled. They were born with this disability. They didn't develop it later in life, which is what all this stuff I'm kind of glossing over is right now. I figured I'd save you the pain of dealing with all of that nitty-gritty when it's not applicable. Okay? 29, once in a while this will apply. This is sort of the grab bag. I leave this blank, but I've seen it come up once in a while. Sometimes the court will say, hey, in 2 years, let's come back in and check if this limited conservatorship is still appropriate. And the court will check this and they'll slap something, slap an attachment on the back saying, hey, in 2 years, we're going to review the appropriateness of the conservatorship. Probate referee appointed. You only need a probate referee if there is an estate. Probate referee is basically the appraiser on behalf of the court. If there is a conservatorship of the estate, you don't got to worry about that. 31, 33, you're going to do, or let me rephrase, I'm going to do an attachment 31 and I'm going to do an attachment 33 that typically are the exact same. I put all the powers that I am requesting, usually the 5 powers from 2351.5, which is every power except the power to control social and sexual contacts in marriage. Those are 95% of the time what I ask for. The power to control social and sexual contacts in marriage are rarely granted, but there are fact patterns where perhaps someone is particularly vulnerable to exploitation, and then one might check those. 1830B, this is typically more for a limited conservatorship of the estate. I do not check it. This order is going to be effective on one of these two. I let the court decide whether it's effective on the date signed or the date minor attains majority. Actually, I would know which one. Usually it's date signed, but sometimes it's the date minor attains majority. I've tried this, but the courts I've dealt with don't typically allow that. Let me give the fact pattern. It's where I'm applying for a conservatorship and the proposed limited conservatee is maybe 17. And I know the hearing is going to be 8 months before the limited conservatee turns 18. And so then it's nice to pave the way, you would think, to make sure, hey, this person's 17 and a half. I already have a court order effective on this person's 18th birthday. The courts I've dealt with just say no to that. which is a little frustrating to me because I like to make sure everyone is secure as possible, but that's a conversation for another time. So, number of boxes checked in items 18 to 34, I let the court worry about that. Number of pages attached, I let the court worry about that. And then this will be dated and signed by the judicial officer. Now, once again, I'm going to re-emphasize that checking the probate notes is incredibly important to make sure all of your forms and your conservatorship is going through and any concerns that the court brings up are addressed. I say that with this form in particular, with the order, because I imagine local practices vary widely in the way that I have sort of glossed over the form in order to give the courtroom to breathe and fill it out the way that it might want to, might not be appreciated by other courts. They might want me to wait until after the hearing or the day of the hearing, or they might want more specifics, but I'm just showing you how I fill it out and what I've done that has worked in my experience. So I hope that helps everyone out. Thanks so much. Have a good one. Bye.